Welcome, everybody. We're so excited to have everybody in class today to talk all about the Supreme Court. And the students have been prepping before you got on. They were playing game shows and questions around the Supreme Court. So they're really excited to learn so much more. My name is Curry Sautner. I'll be in the chat with everybody. So if you have any questions for our great guests today, please feel free to ask in the chat or the Q&A. Today, we have Professor George with us, who's an amazing professor and also a fantastic constitutional lawyer. Now, I was really fascinated that you are an expert in jurisprudence and understand that as a big concept. So I thought we could kick it off to Jeff Rosen and yourself, and you could also explain to our students, what does jurisprudence mean too? Back to you, Jeff.
That sounds great. And I'm so excited to talk to Professor George too, because as you say, he's such an important scholar and has shed so much light on really crucial questions, including the founders and natural law. And Professor George, we had the most wonderful program last night about the Founders Library, and Colleen Sheehan was on. And I asked her, what were some of the great thinkers and particular books that influenced James Madison? And as you know, drawing on her great book about Madison and classical republicanism, she said Madison, in thinking about American government, was especially influenced by Aristotle's Politics, Book 5. I know we're kind of getting into the details here, but I thought it would be great, because I'm so interested to learn about it. You teach at the Witherspoon Institute at Princeton University. John Witherspoon was an early president of Princeton who also was one of Madison's teachers, and he thought natural law and natural rights were really important. So give our friends a sense of what John Witherspoon taught James Madison about natural law and natural rights.
Well, Jeff, first, thank you for having me on the program. And Carrie, thank you. And congratulations to you, Jeff, and to the whole team at the National Constitution Center for the great work you do at educating our people, especially our young people, about the Constitution. One of the things James Madison said was that only a well-educated people can be permanently a free people. And by well-educated, he especially meant educated as to the principles of their government, civics, as we would call it today. He knew that in a regime of freedom, in a Republican democracy, as we would today call it, everything depends on the people. Here the people rule. That's the whole idea of republicanism. But people can't rule well and can't preserve their system if they don't understand their system, if they don't understand the principles of Republican democracy. And that's why only a well-educated people, and people well-educated in the principles of civic life, of constitutional law, can be permanently a free people. And your work, the work of the National Constitution Center, helps to keep us permanently a free people by educating our people. Now, you've asked me about Witherspoon, and I'm very excited to talk about Witherspoon. He was a Scottish Presbyterian minister, came to this country, had a very thick Scottish accent, was a preacher, of course, a preacher of some renown, but also an educator, one of the original faculty members at Princeton University, which was founded as a Presbyterian institution, mainly for the training of ministers, but not exclusively. James Madison didn't become a minister. Madison came here as a student and stayed beyond his graduation, his Bachelor of Arts degree, to study Hebrew. So he was also Princeton's first graduate student. Now, what did he learn from Witherspoon? Well, as you can imagine, from a Presbyterian minister, he learned the Bible. But Witherspoon was a man of the Enlightenment as well, a man of broad learning, and someone who knew the importance of educating people not only with respect to the Jewish and Christian scripture, but also with respect to what much later a famous 19th century British figure, Matthew Arnold, would describe as the best that's been thought and said. Now, if you're going to educate people on the best that's been thought and said, that means you have to reach all the way back, not only to Jerusalem, but to Athens and to Rome. And so Witherspoon had in mind, we've got to teach our young charges Aristotle, Plato, Cicero, St. Augustine, and on and on. And of course, those great thinkers in Athens and Jerusalem were fundamentally concerned, I should say Athens and Rome, those great thinkers of classical antiquity, as we sometimes call it, were fundamentally concerned about the moral foundations of life, the moral foundations of our individual lives, of our family lives, of our community lives, the lives we lead in the polis, in the political community, for us, the nation, we would say. So they wanted to know what distinguishes good law from bad law. Is it just how it's made? Is law good if it's democratically made and bad if it's not democratically made? Well, those ancient thinkers weren't too keen on democracy. Some of them, though, did incline toward the idea of republicanism. And the question of the relationship between republicanism and democracy is a question that vexed all of the American founders, and most especially Madison. And you see this in the 10th Federalist Paper, where he contrasts republicanism, which he likes, with democracy, which he doesn't like, thinking of democracy as leaning toward or leading to mob rule. Republicanism shares with democracy the idea of the people being in charge. If you're a Republican, you're in that way also a Democrat. But he framed and ratified under the, and participated in the ratification of, under the, here the tutelage of Witherspoon is very clear, a form of government that, while it had significant democratic elements, had checks and balances, had checks on, limitations on democratic rule. So, for example, we have a very democratic House of Representatives, but a not very democratic Senate. California, big population state, has 52 members of Congress. Wyoming has 1. Yet Wyoming has the same 2 senators, the same number of senators too, as California. That's not very democratic, but it wasn't designed to be democratic. The Constitution under Madison and the other founders' deliberate design has its democratic elements, to be sure, but it also has checks to prevent tyranny, to prevent the tyranny of the majority, to ensure that civil liberty is protected. And those are principles he learned from Witherspoon, who in turn got them not only from the scripture, from the Jewish and Christian sources, but also from classical antiquity, from Cicero and from Aristotle and from Plato and from the other great writers of antiquity. Now, you've asked me, and I'll conclude the answer to this question with this comment about natural law. This is the idea pronounced most powerfully in our own age by Martin Luther King in his famous letter from Birmingham jail, that there is a distinction between just and unjust law, and that's because the human law is not ultimate. The human law is not the highest law. The law made by the legislature of Connecticut or by the Congress of the United States or by the Parliament of Britain is not the final truth. In fact, its goodness or badness is conditional. It depends, this law of Parliament or Congress or the legislature of New Jersey, on its conformity to the higher law, to the moral law. The law we sometimes refer to as the highest law. Now, this gets us into a really interesting question about its relationship to divine law when we start talking about the highest, but the law that's superior to the humanly made law. And this Martin Luther King, following the great tradition going all the way back into antiquity, calls the natural law. So Martin Luther King says, I believe in obeying the law when the law is just, but I don't believe in obeying the law when the law is unjust. How do you know whether the law is just or unjust? It depends on its conformity to natural law and divine law. The difference between the two being natural law is the law that we can understand, the moral law that we can understand by natural reason, by the application of our intellects. And so the great pagan thinkers could understand the natural law, even though they didn't have the revelation of scripture given to the Jews, to the Hebrew people. The divine law, that's revealed, but the natural law can be known by anyone who's willing to think carefully and clearly about moral questions.
That's wonderful. I'm so glad I asked. And you've opened up such a world of further exploration to us by introducing us to these questions of natural law, moral law, and ordinary law. We're supposed to talk about judicial review. So this leads me to ask, about the degree to which the framers, including Madison and Hamilton, believed that natural law was relevant for judges when they struck down laws. So our friends from the class know that Hamilton in Federalist 78 said when there's a clash between the will of the people represented by the Constitution and the will of legislators represented by ordinary laws, judges should prefer the principle to the agent and strike down the ordinary law in the name of the people's will. Did Hamilton and Madison also believe that judges should consult natural law in striking down laws? And what was the relation between natural and positive law in the theory of judicial review?
Well, that's a complicated question and one on which reasonable scholars disagree. I have a view about this, but there are people who disagree with me about it who are perfectly entitled to their view and are people of great learning and intellect. It's in a certain sense a perennial question for us Americans. It goes all the way back to the beginning. Judicial review does not appear by name in the Constitution. When we look at Article 3, which creates the Supreme Court of the United States, invests the judicial power of the United States in the Supreme Court, it doesn't mention the Supreme Court striking down laws. But you're right in making his argument for ratification of the Constitution, together with Madison and Jay. Hamilton, in paper number 78, anticipates that the judiciary will face cases in which the legislature, say the Congress or the state legislature, will enact a law that, in the opinion of the courts, is contrary to the Constitution. Well, yes, Hamilton says in that case, since the Supreme Court is supposed to be interpreting and applying the law, and the superior law is superior to the inferior law, the Constitution being supreme law of the land by its own words is superior to mere legislation. It's the obligation and authority of the judge to strike down the law. But the judge has to be acting truly in the name and for the sake of the Constitution. So this raises the question, well, how does he interpret the Constitution? Is it by reference exclusively to the intent of the framers and ratifiers of the provision under review? That's a very popular view these days, sometimes called originalism. There are many different variants of originalism, so we shouldn't think of it as a monolithic thing. But there are others who say no, and you find such people now on the politically conservative side as well as the politically liberal side who say no, originalism is not the right understanding. The judge should look to morality itself, to the natural law, in figuring out what the Constitution means and applying it, including when exercising the power of judicial review. Now, what's the argument for that? It goes something like this. We know for certain, this is not a contested matter. This is not a point on which reasonable people disagree. We know for certain that the founders believed that they were acting on and entrenching in our Constitution principles of natural law and natural rights. That's the point. They wanted a Constitution that would effectuate natural law and protect natural rights. So the reasoning goes, of the people I have in mind now, since that was their goal, in order to play the proper role in giving effect to what the framers and ratifiers in fact wanted, the courts themselves have to take into account natural law. For example, Professor Hadley Arkus of Amherst College makes this argument. Recently, again, on the conservative side, Professor Adrian Vermeule at Harvard University has been making an argument like this. For many years, it's been made by people on the other side, sometimes in the name of what's called living constitutionalism, that the Constitution has to be a living document, and therefore judges have to make independent moral judgments and not just rely on the text and the historical understanding. One of my own teachers, Ronald Dworkin, the late Ronald Dworkin of Oxford University and New York University, had that view. Now, if we go all the way back to the beginning of this debate, and this goes back to the beginning of the Republic, you might remember, Jeffrey, I might be saying something here that's obscure to many of our viewers, but you will remember the case of Calder against Bull, in which Justice Iredell and Justice Chase, though coming down on the same side when it comes to the decision of the case, disagreed about whether judges, in interpreting the Constitution or the laws more generally, should give effect to independent moral judgment. Justice Chase said sometimes they should. To protect the principles of Republican government, they must do that. Justice Iredell said, no, never. Now, why did Justice Iredell say never? Because he said, on these questions of natural law and natural rights, while there's no doubt that the Constitution is meant to effectuate natural law and protect natural rights, on these questions, even the purest and ablest of men have disagreed amongst themselves. And where the ablest and purest men disagree, courts should not come in and put a thumb on the scale one way or another. So judges should interpret the Constitution much more strictly and not bring into their deliberation, into their decision-making, any independent moral judgment. Iredell wanted to keep a strict separation between legal interpretation and judgment on the one side and moral interpretation and judgment on the other side. Not because he didn't believe in morality, he did. Not because he didn't believe that the Constitution was meant to, as I say, effectuate a certain morality, the principles of natural law. He did. It was all about what the proper role of the judge was, if the judge was to respect the integrity of the Constitution.
This is fascinating. I'm so glad our friends are hearing you lay out this debate so clearly. And I think it might help them and all of us to talk about some specific examples. So you mentioned Professors Vermeule and Arcus on the more conservative side and Professor Dworkin on the more liberal side, who said that judges should make independent moral judgments about what they think natural law requires. Maybe give us some examples of the kind of cases that Professor Arcus or Professor Vermeule might think should be decided by consulting natural law or moral judgments today.
Well, of course, the most divisive and controversial issue that we've had in our constitutional law in my lifetime and yours, Jeffrey, has been abortion. Now, originalists like the late Justice Antonin Scalia, for example, say, since the Constitution doesn't mention abortion at all, since it doesn't seem to imply anything about abortion at all, the Constitution should be understood as being silent on the question. And what happens under our Constitution if the Constitution is silent on a question? What does that mean for judges? Well, what that means is the matter is left to legislatures, either at the state level or at the national level, the Congress in the case of the national level. So Scalia says we interpret the Constitution by reference to its original understanding. We look, for example, at the 14th Amendment. It was not originally understood to have anything to do with abortion. That was a separate issue handled by legislatures. So the Supreme Court should not interfere in the issue at all. It should not do what it did in 1973, which was create a right to abortion, but it shouldn't do what some people today say it should do, which is not only overturn its 1973 judgment in Roe versus Wade, creating a right to abortion, it should rule that states and the national government may not permit abortion because the natural law requires that the unborn child be protected. Abortion is a violation of the human rights, the natural rights of the unborn child. Therefore, the Constitution actually forbids abortion. Now, on that question, Scalia's position is challenged by Professor Arcus and Professor Vermeule on the one side, and Professor Dworkin on the other. Professor Dworkin thinks that the court did the right thing in Roe versus Wade, not only getting the right answer that there should be a right to abortion. He thought that the court did the right thing in treating the matter as one appropriate for judicial resolution, one that needn't be and shouldn't be simply left to the states. Arcus and Vermeule agree with him on that latter point. They say, yes, that's right. It shouldn't be left to the states. Given our system, given the Constitution's effectuation of natural law, the judges should weigh in on the question, but they think Dworkin gets the wrong answer on what the specific ruling should be. They think Roe should be overturned, and in its place should be, again, imposed by the court, a ruling that unborn children must be protected under the Equal Protection Clause against abortion across the country, eliminating the legal permissibility of what's sometimes called elective abortion. That is, abortion that's not for protect the life or health of the mother, but for social indications or for personal choice.
Thank you very much for laying that out so clearly. This is highly timely because, as we all know, just last week, the Supreme Court agreed next term to hear a case arising out of Mississippi that bans most abortions after 15 weeks and may provide the court with its first opportunity to reconsider Roe v. Wade. Now, we have a great question in the chat from Richard Procida. What about the natural rights of women and girls? And it's a good question because some justices and scholars, including Justice Anthony Kennedy, seem to be invoking a kind of natural rights approach when they said that there's a right of autonomy of women that prohibits the state from regulating abortion. So given the fact that there are plausible natural law arguments on both sides of this case, on the one hand, Justice Kennedy says that women have a natural right not to have their autonomy infringed. And on the other, Professor Arcus and others say that the unborn fetus has a natural right to be protected from the moment of conception. How can judges choose among these competing theories?
Well, there are different views of what the natural law requires. And this is precisely what led Justice Iredell all the way back at the end of the 18th century in that debate in Calder against Bull with Justice Chase to say judges shouldn't be resolving those questions. Where the purest and ablest of men disagree on a moral question, it should be left for what we would today call democratic resolution. In other words, legislative determination, not judicial. But Professor Dworkin reads it exactly as the questioner reads it. He says, well, no, a correct understanding of the natural rights of the situation are that women should have a right to terminate a pregnancy, even if it means ending the life of the unborn child. But on the other side, Professor Arcus and Professor Vermeule say, no, you got the substantive natural law wrong there. The natural right in question is the right of the child not to be killed. So there are two separate questions, and it's very important to always keep the distinction in mind. The one question is, what should the public policy of the nation be in order to be most just, to be most in conformity with natural justice, with natural law? That's question one. Question two is, which institution should decide what the right answer is? And even that has got to be divided in two ways because we have two versions of that. One is, should it be an institution at the national level or at the state level? Always an important question. Some people think abortion is just a state issue. Federal government should stay out of it. Courts should stay out of it. Congress should stay out of it. It's a state issue. But then there's the other point of view that says, no, it's a national issue. So we've always got to ask, should it be resolved on a state level or at the national level? And then even when we've got that resolved, we have to ask which institution among the separate institutions of government at the state or national level should resolve it. Should it be the executive branch acting as governor or president? Should it be the legislative branch, the state legislature, or the Congress in the case of the national government? Or should it be the courts? Again, whether the federal courts with the Supreme Court at the top or the state courts. So all of these issues end up being complex. And it's really important. Let me say this to the students. It's really important as you think your way through these constitutional questions, not to run those different questions together. Keep them separately, go analytically, go one by one. What's the right answer? Which institution gets to decide whether it's the right answer? Should it be at the national level or at the state level?
Absolutely right. Thank you so much for emphasizing the importance of breaking it down. As Curry writes in the chat, see how he's breaking it down to distinguish between political and constitutional questions. And we always tell students of all ages before every National Constitution Center program, let's separate our political from our constitutional views, asking not what we think the government should do, but what the Constitution allows or forbids it to do. And you are encouraging us to break it down in precisely that way. I am, this is always the point in the show when I'm reluctant to turn the mic back to Curry because I have so many questions for you, Professor George. But I think because we are here to talk about the Supreme Court, before I turn it back to Curry and the student's question, what's the issue, either about the way the court works or the current debates about activism and restraint, or anything you like that you most want the students to think about and to learn more about as they think about the Supreme Court and the structure of Article 3?
Well, Jeffrey, it's precisely the one that you flagged just a moment ago. So I want students to remember that there's a distinction between the political and the juridical, between the legislative and the judicial. So the temptation that you will experience, and we all do because we're human beings, the temptation we experience is to suppose that if I were on the Supreme Court, I should vote for a resolution that would be just like the resolution I would vote for if I were a member of the legislature. But that's bad. That's a mistake. Those are two separate things. And if you're doing constitutional law correctly, indeed, if you're doing constitutional law and not just reducing everything to politics, if you're honoring the Constitution, you should be able to point to certain issues on which, as a legislator, you would vote one way, but as a justice, you would vote a different way because you would not think it's within the purview of the court to resolve the issue or resolve it in the way that you would like to see it resolved if you were a legislator. I can tell you about a case like that in my own case. So I'm morally opposed to the death penalty. If it were up to me, I would abolish the death penalty nationwide. I've done some work, some writing, and some speaking against the death penalty. Now, sometimes the death penalty has been challenged. Some people have claimed that the death penalty is a violation of the Eighth Amendment, which includes a provision prohibiting cruel and unusual punishment. People say it's inherently cruel or unusual, and therefore it should be abolished. I wish I could believe that, but if I do a disciplined, serious constitutional interpretation, I realize that the Constitution does not forbid the death penalty. It'd be great, from my point of view, if we amended it to forbid the death penalty, but it doesn't forbid it. In fact, it contemplates it. If you look at the due process clauses of the 5th and 14th Amendments, for example, it says no person shall be deprived of life, liberty, or property without due process of law. It anticipates the death penalty, just as it anticipates imprisonment, liberty, or monetary fines or forfeitures, property. It's just that, of course, it has to be done according to proper legal proceedings. So someone who is accused of a capital offense or offense for which he can be imprisoned or subjected to a monetary fine has to be given a fair trial. Here's just one example, and it just happens to relate to my own thinking, in which if I were on the Supreme Court, I would be forced to say, no, the death penalty is constitutionally permissible. It might be wrongly applied in any particular case, but as a matter of principle, it's permitted. Although if I were voting in the New Jersey legislature or in the Congress of the United States, and the question was whether to abolish the death penalty in my jurisdiction, I would vote to abolish it.
Wonderful example. And friends who are listening, let's remember Professor George's challenge. And each of us should try to identify an issue where our political and our constitutional conclusions diverge. He just gave an example for his own, for the death penalty. I want you to think about what's an issue that you really care about politically, but if you were a justice, think that the court should reach the opposite result. For example, you think gun control is really important, but you think the Second Amendment forbids it, or you think it's a really bad idea, but you think the Second Amendment allows it. And when you identify those issues, then you can be sure, as Professor George says, that you're being principled constitutional thinkers, and identifying those issues is a wonderful test for how principled you can be. Okay, I've got to turn it back to Curry with great thanks to you for shedding so much light. Curry, what kind of questions do we have from the students?
We have a lot, and I've tried to consolidate them because I know our time is running tight, but this has been so fantastic for us to kind of watch you pick them apart and parse them out on levels as well. And it's a really hard skill that we're all trying to learn. So that was a great model that we'll follow. So first question, and it has come in a few times, is about the number of Supreme Court justices.
Wow.
So many questions around that. I'll just leave it nice and broad, but like 20 of our students were wondering if you could speak around the number of justices.
Well, the most interesting fact about that is that the Constitution doesn't set the number of justices. Again, let's go to Article 3. That's the article about the judicial power of the United States. Article 1 is about the legislative power. Article 2 is about the executive power. Article 3 is about the judicial power. Again, keeping things separate. Very important to analyze things and keep them separate. So the third article says the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time establish. And then it goes on to tell us some things about the jurisdiction of the Supreme Court, that in a small number of areas, the court will have what's called original jurisdiction. That is, cases will begin there, trials will be held there. But in most cases, it won't have original jurisdiction. It'll have what's called appellate jurisdiction. That is, it will be reviewing decisions by lower courts. Now, again, notice that the Constitution in Article 3 doesn't create those lower courts. It only creates one court, the Supreme Court, but it anticipates lower courts, which will be created by Congress, and Congress has indeed created these lower courts, did all the way back to the beginning of the Judiciary Act of 1789. But it doesn't tell us anything about the staffing of those courts or of the Supreme Court of the United States. It doesn't say that there will be 9 justices or 5 or 113. It doesn't say anything about that. So what happens when the Constitution is silent on an issue? Here, Justice Scalia is clearly right. When the Constitution is silent, we sometimes debate whether he's right about whether it was or was not silent on this or that issue. But here it clearly is silent. Where it's silent, it's up to the legislature. In the case of the national government, the Congress. So Congress has to decide how many justices will sit on the court. I believe, Jeffrey can correct me if I'm wrong here, there have been as few as 5 early on. I believe there has been as many as 10. I think at one point around the Civil War, we had as many as 10, but it's been 9 for a very long time. And when things go on for a very long time, they become what we sometimes call traditions. And traditions have a certain standing because other things get built up around these particular traditions. So while we cannot say that the Constitution requires there to be 9, many people believe, in view of our traditions and of the stuff that's grown up around them, that the integrity of our Constitution depends on us sticking to the figure 9. And so when Franklin Delano Roosevelt in the 1930s got very frustrated with the Supreme Court of the United States, and boy, did he get frustrated, kept striking down his New Deal programs just as he was trying to get the nation out of a deep depression, and he felt we needed these programs, and he had tremendous support, Supreme Court striking them down. He cooked up a plan and tried to execute a plan to expand the number of justices effectively to 15. Why? Because it would give him 6 new appointments, 6 more above the 9 already on the court. And that would enable him to appoint justices who would favor his New Deal programs and uphold their constitutionality and change the outcomes of cases. Well, this scandalized even Roosevelt's supporters. Why? Because it looked like what it was, an attack on judicial independence. And we Americans rightly prize the independence of the judiciary. Not all judiciaries around the world, historically or today, are independent. Many are under control of the political leadership. We're very blessed, very fortunate to have an independent judiciary. And this is why even many Democrats, even supporters of Roosevelt, even some of his friends, opposed the court packing plan. And now again today, there is sentiment arising from people who are frustrated with Supreme Court or feel that the current Supreme Court is making bad decisions, or that some members of the court were put on illegitimately for one reason or another, who are arguing that we should expand the number, maybe go up to 13 to shift the ideological balance of the court. I understand the motivation for that. If you're in favor of that, you're completely entitled to your opinion. You need to be able to make a good argument. You need to be able to answer the counter arguments. But the counter argument you will have to answer is this is a threat to the independence of the judiciary. And this is why I oppose it. I would oppose it whether it comes from the right or the left, Republicans or the Democrats. It has the same problem it had in the 1930s when Roosevelt tried it. It undermines the independence of the judiciary. And that's, as I say, a principle that we're really, really lucky to have.
Absolutely. Okay, one final question, kind of bringing up to today. Multiple students messaged in before the class started. Can you please talk about the cheerleader case? So, it's really important to students. This is a case where the Supreme Court is looking at their lives in schools. And when we think about political and constitutional tensions, and somebody said it in the chat, I think it was Jacqueline, which was brilliant. We can have, a battle of the branches going on in our own head as well, between what we think we should do and what we think the Constitution allows for. This case kind of is doing that with a lot of Americans too.
Yes, indeed. We need to go back now several decades to the time when the Supreme Court, I believe it was in the circumstances of the Vietnam War, Jeffrey, again, correct me if I'm wrong about that, decided that, look, the First Amendment applies to the whole of life, and it applies to everybody. It applies to young people as well as old people, minors as well as people who are over the age of 18 or 21 or whatever counts as majority or counted in majority in those days. And it applies not only on the streets, but in the classrooms. And so students have First Amendment rights that their schools have to protect. And among those First Amendment rights are the rights to freedom of speech, the free expression rights that we have under the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. So since, I believe it was a case of wearing black armbands, since adults on the street could wear black armbands, children in schools were entitled to express their opinions about the Vietnam War or anything else by wearing black armbands. Now, in the free speech area, not all speech is protected. So there are certain broad categories of speech which are not protected at all. Defamation, incitement to violence and breach of the peace, conspiracy to commit a crime, false advertising. But in addition to these broad categories, there are also what are called time, place, and manner restrictions on speech, which are permissible because they help us to maintain an orderly and decent and livable society. So while I have every right to go out onto the streets of Princeton, New Jersey at 2 o'clock in the afternoon and shout, vote for the libertarians or vote for the socialists, I don't have the right at 3 in the morning to walk into a residential neighborhood, maybe with a sound truck, and blare out, vote for the libertarians or vote for the socialists. Not because the political leadership is opposed to my being for the socialists or being for the libertarians, but because people need to get a night's sleep. Well, it's the same in schools. Time, place, and manner restrictions are legitimate where they uphold order and make it possible for the mission of the schools, the educational mission of the schools to succeed. In that case I was referring to from the Vietnam era, what the court essentially decided was the wearing of those armbands does not, the Tinker case, thank you, Carrie, yeah. In the Tinker case, the wearing of the armbands did not disrupt the educational mission of the school. It did not create a problem that impeded that mission. And that's, I predict, how the Supreme Court is going to handle the current case. They're going to say, well, look, does this young woman's extracurricular posting of obnoxious or foul language have a disruptive effect on the educational mission of the school? Now, you can imagine how the argument is made either way. And of course, that's the argument made by the lawyers on the competing sides. And the justices across the ideological spectrum, and you may not get a straightforward ideological division on this. It might be a very mixed up set of justices here. You might find some liberals voting with conservatives, conservatives voting with liberals. But each judge's decision on the matter, vote will be cast basically on the basis of a judgment of whether this extracurricular activity is disruptive of the school's mission. If I were predicting, and I shouldn't predict because it's the most hazardous thing that a constitutional scholar can do on any case, you name it. And I've been notoriously wrong in my predictions in the past. If I were predicting, I would predict that they're going to say the school's violating her constitutional rights mainly because this is stuff outside of school. If it were happening in the school, using school equipment on school property, it might come out differently. But I think this is going to be a highly, if I can use this lawyer's jargon, fact-sensitive case. And the most relevant fact I predict will be that she's not in school.
I think this is fascinating. I love that we went from like the colonial era all the way to a modern case. And students, this will come out hopefully in the next 6 weeks, right, Jeff? We should hear an answer in the next 6 weeks. So what a great way to break it down for everybody. They can be watching. I also put the link to the SCOTUS blog in the chat, and we'll send it out to you afterwards. But thank you so much. Thank you for our history lesson, our lesson in natural rights and natural law, which I absolutely love. It's so fascinating. And then also breaking down how do we really understand the questions in the case and parsing them out, as well as a current case that we're going to be looking at and how to look at it. So thank you so much. That was a lot in 40 minutes. So that was wonderful. Jeff, back to you for a wrap up.
Just to echo Curry's thanks. Thank you so much, Professor George. Our friends in the chat are thanking you as well for being a great teacher and saying your students are very lucky to have you guiding them. And we enthusiastically agree. Thank you for sharing your time with us. And have a
Thank you, Jeffrey. And I want to say to all those students out there, think Princeton. I'd love to have you.
That's great.
Thank you, everybody, so much.
Bye.
Thanks, everyone. Have a good weekend.